Good morning, everyone. And while we are waiting for this webinar to populate, my name is Tim Sink. I'm president of the Greater Concord Chamber of Commerce. And I want to welcome you here for this very important webinar. We're very fortunate to have two speakers with us today that really know their stuff on this. So we're going to cover some very important information that you need to know. And please know that this is a bit of a moving target, so it is likely that we'll do some follow-up webinars on this topic going forward. Before we get started, just a couple of quick announcements. We have a lot of non-members on this webinar. Welcome, glad to have you here. Obviously, I'd be crazy not to make a pitch, but love to have you take a look at membership within the Greater Concord Chamber of Commerce. We are among the largest chambers in the state with more than 900 members, lots of different benefits that will help your business in terms of marketing and networking and educational programs such as these and leadership development and really much more. So if you're interested, please contact us and we'd be happy to talk to you about that in a little bit more detail. Also wanted to cover some upcoming events that we have in case you're interested in participating. We have another slide that will talk about some upcoming events. Our annual Meeting and Citizen of the Year event is coming up next Wednesday, October 27th at the Grapponi Conference Center. We do monthly business after hours. We're back in person again. And our next business after hours is November the 9th, 5:30 to 7 p.m. at Grapponi Ford Mazda. And we've been having very good attendance at these. These business after hours have bounced back nicely. So averaging around 150 people attending these. We've got a very robust Concord Young Professional Network, and their next event is on the 17th of November, 5:30 to 7:30 p.m. in downtown Concord at Laliste Designer Resale. It's a very cool store in downtown, and it's being done in partnership with Wine on Main, a wine store right next door. So might want to check that out. And then last but not least, at least in the short term, we've got our monthly forum is on some major development projects in Concord. So that takes place on Thursday, November 18th. It's a luncheon from 11:30 to 1 at the Holiday Inn. And we've got some great speakers that are coming to talk about some major projects that are in the works here in Concord. So that's it for the announcements. It's now my pleasure to introduce our speakers. But quickly before I do that, there's going to be an opportunity for some Q&A. From any of you, and very simple, if you would like to ask a question, there's a little Q&A icon on the bottom of your screen. So just hit that. You can ask a question anonymously if you want, or you can do it not anonymously. Type in your question and we will get to as many as we can at the end of the presentation. And all the presenters can see these questions as well. So introductions. We have two terrific speakers. Attorney Karen Whitley is a shareholder at She & Finney's Employment Law Group, where her practice focuses on management side employment litigation and counseling. She works closely with human resource professionals across Massachusetts and New Hampshire, solving complex leave of absences, discrimination, wage and hour issues. Also with us today, attorney Jim Reedy is a well-known management side employment lawyer who represents organizations ranging from multinational corporations to closely held businesses to not-for-profit entities and public sector employers. Jim chairs the She & Finney's Labor and Employment Practice Group, which is recognized as one of the best in New England. He presents seminars on a wide range of employment law topics. He is the moderator of New Hampshire LaborNet. It's a very popular internet discussion group for HR professionals. And he's a workplace law resource for several media outlets, including CNN, The Washington Post, The Wall Street Journal, Bloomberg, Law 360, Kiplinger, NBC News, the Associated Press, as well as several other local media outlets. So thank you to our speakers. And I think Jim is going to open up the remarks, and then we're going to get a little bit of back and forth from both of these presenters. So folks, thank you so much for doing this with us.
Great, thanks. Thanks, Tim. And thanks to Tim and the staff at the Concord Chamber. We're thrilled to be here with you today, virtually. But as Tim said, an important topic. And, you know, as 9/11 defined a generation, I was actually thinking about this today. My kids my kids are the same age as Tim's kids, and they've never known the Patriots or the Red Sox without winning banners and so on. And it's like, okay, well, perhaps this will also in part define their existence apart from the sports teams and so on. COVID, there's no question, is a serious issue, both a health issue, but also as it affects business and it affects society in general. And if you think back a year ago, we thought we were done, but we're still in the throes of this pandemic. And I heard recently it said, well, soon it will become an endemic, meaning it's still going to be with us. And so we're dealing with the realities, both in our personal health, our family's health, the health of our businesses, the health of our communities, and so on. And, I think that, as Tim said, this is an evolving story, just like the virus has evolved and morphed and mutated, so has the legal response to this. So Karen and I are going to cover a lot of information today, but there's still information yet. In fact, you think about it, government has responded, and well-intended government has responded both in the state, local, and federal level. And let's go back a little bit to March of last year, where the federal government adopted the Family First Corona Response Act, FFCRA, with emergency sick leave and emergency family leave, and all that went along with that. But with that, which again was legislation that was adopted in a week. And I mean, that in and of itself is historic, that a piece of legislation made its way through Congress to the president's desk and was adopted. Now, then the U.S. Department of Labor had to basically sort that out with FAQs that went on for some time. And defining part of Karen's existence and mine, we were talking about it just before we went live this morning, asking about the OSHA guidance. Yeah, we're those people that focus on those things and wait for them to come out and digest them and then try to get the information out to you folks. But first was the FFCRA. Shortly thereafter was the CARES Act, and the CARES Act was augmenting unemployment benefits and also providing the PPP loans to keep businesses afloat and getting payrolls restored. Followed next by extending the FFCRA, which was supposed to expire effectively December 31st, but then it went on till March of this year. And then, of course, as you know, the American Rescue Plan this summer. And in many ways, for those that watch late night commercials or did watch late night commercials, it seems like a Ronco commercial. How much would you pay for it? But wait, there's still more. And the still more is what happened on September 9th. And that was the president came out with path out of the pandemic executive order and what that means. And that's what we're going to talk about today. While it was broader and it dealt with federal employees, it dealt with healthcare providers, we're going to focus on federal contractors because New Hampshire has a lot of federal contractors, and we're going to talk about large employers as well. So I'm thrilled again to be joined by my partner, Karen Whitley. Karen's got a great deal of experience in this area, spends a lot of time, as other members of our group do as well, assisting clients to sort out the many issues, and there are many issues associated with this. Because if it was as simple as just talking about a law or regulation or guidance, but when you get into the bug dust and the particulars of, well, this is this person's accommodation, or this is this person's objection, or this is where he or she works, remotely or in the office, and the push and pull. And Tim was talking about that before, which was the stressors on business, one, to comply and keep a safe workplace, but on the other hand, retaining talent. And we're in that strange sort of perfect storm in that regard. So as we look at our agenda this morning, in the next slide there, thank you. So we're going to talk quickly about path out of the pandemic and what was involved and what has happened since September 9th. Who is a covered employer? Guidance for federal contractors. And there was guidance that came out on September 24th and again on September 30th, providing a bit more information, but there are still questions that remain. And when we refer to ETS, that's the Emergency Technical Standards, and that is what is to be issued by OSHA for implementing the standards for large employers, meaning employers with more than 100 employees. And we'll talk about that. And the exemptions and the opt-outs that might be available, exemptions that are available to the vaccine and the opt-outs that might be available, testing and what's involved with testing, record keeping, and legal issues. And principally what we're talking about there is reasonable accommodation. And we'll also talk about the potential fines and penalties or consequences for non-compliance. And as Tim said, we've got time for questions and answers. So the next slide is, so why path out of the pandemic? And that's a question that's been asked by businesses large and small. Why? Well, because the virus, as viruses do, it morphed, it changed. We had the Delta variant and then Delta Plus and other variants. There's Lambda, there's Mu, and there are others. But Delta in particular and Delta Plus have been particularly infectious. And so with that, starting late summer and into where we are at this point, actually it was mid to late summer, infections were on the rise. And then with that, hospitalizations and deaths and so on. So we were back in that cycle where we did not want to be. And we thought with, or in the early days, they talked about herd immunity, but they said, well, with vaccination, if we get to say 70% vaccination, then, fully vaccinated, then we won't have this issue anymore, that there will be no place for the virus to go. But then, of course, if we have breakthrough viruses, breakthrough infections for those who are vaccinated, and you also have a stubborn part of the population, and not meant to disparage those that don't get the vaccine, but there's a segment of the population, national population, that is not vaccinated, and that's what the president was focused on. So, not wanting to return to shutdowns of last year, the president announced his executive order, path out of the pandemic, and so that's where we find ourselves. And I'm turning this back over to Karen to talk about what is involved.
Good morning, everybody. So yes, thank you. So Jim has mentioned the path out of the pandemic, and it is a 6-part strategy presented by President Biden on September 9th. You'll see we have 5 here. One of our prongs did slip off the slide, but we'll get to that. So there were 6 parts, or are 6 parts: vaccinating the unvaccinated. And this is largely where we'll focus today. Second is further protecting the vaccinated, which largely relates to booster shots. Third, keeping schools safely open. So expanding vaccination to students and calling on states to require mandatory vaccines of staff in schools. Increasing testing and requiring masking goes pretty much without explanation. Improving care for those with COVID. And then the 6th and final part of that strategy is protecting economic recovery, which includes support for small businesses and the Paycheck Protection Act process getting streamlined. So those are the 6 parts, and we'll focus, like I said, mostly on the first, vaccinating the unvaccinated. So as part of the path out of the pandemic, Biden's announcement on September 9th, which was accompanied by an executive order as well, called for full vaccination of federal employees and federal contractors, and I'll spend some time talking about that. And then also healthcare facilities and large employers, and Jim will cover that. As Jim mentioned, there may be test out options in some scenarios, although largely not for federal employees or contractors. And religious and medical exemptions are preserved for each of these categories of workers. So we'll spend some time towards the end of this webinar talking about that process. And then finally, Biden also did talk about paid leave to get vaccinated. And currently we don't have much of information about that. We are waiting for additional guidance on that. So turning first to federal employees, there are slightly different rules for federal employees and federal contractors. So just looking first at federal employees of the executive branch, those were the employees who were covered by Biden's announcement. And those individuals must be fully vaccinated by November 22nd. Except in limited circumstances where they might be eligible for an exemption based on disability or religious belief. So what that means is all shots must be in arms by November 22nd, plus the 2-week waiting period must have passed, which means that the last dose must have been received by November 8th. And there is talk that people who have not gotten the second shot by November 8th can start to be disciplined as soon as then, because they won't then have the 2-week waiting period to be vaccinated by November 22nd. And under this plan, there is no testing opt-out generally for federal employees or federal contractors, meaning that once that deadline passes, generally there's no opt-out for current employees, and that they can't just wear masks and social distance and be tested weekly and avoid the vaccine. I do want to point out that this does not excuse remote workers. So even though somebody may be 100% remote, if they're a federal employee, they are not excused from the vaccine requirement unless they meet some other limitation, such as a disability or religious exemption. I will note though, just go back one second, Trieste, but I will say that with regard to the testing, there was a guidance that was put out on October 4th, which does give some hope that testing protocols may be allowed for people who are given a reasonable accommodation, for federal employees given a reasonable accommodation, or who need to delay their vaccine. For example, if they have COVID, they're not supposed to get a vaccine right away, or if they have some other immunocompromised situation where they need to delay the vaccine. It is possible that there may be some sort of protocol. We don't know what that is yet, but that was mentioned in an October 4th guidance. Also, for new federal employees, they are also supposed to be fully vaccinated by November 22nd. But if there's some sort of mission critical reason that needs them on site doing work and they're not fully vaccinated yet, there is an ability for them to continue to work following various safety protocols while the vaccine process works its way through. So next slide. Now, the executive order that Biden issued does highlight the need for federal contractors to be vaccinated in order that federal employees are fully supported by vaccinated folks. So the federal contractor guidance does give a little bit more time, but it is very broad, and it is causing some degree of alarm with federal contractors because it covers not only workers who are working on federal contractors, but employees who are working in connection with federal contracts. So this is very broad. And these individuals need to be fully vaccinated, although they can get an exemption for religious or medical reasons. They need to be fully vaccinated by December 8th. As Jim mentioned, there have been a couple of guidances. One was put out on September 24th by the Safer Federal Workforce Task Force. It's a mouthful. And that guidance outlines a couple of things. First of all, it provides some definitions. So employers who are wondering whether they're going to be covered as a federal contractor can look to that September 24th guidance to see whether that would cover them, whether the definitions cover them. But that guidance also talks about the safety protocols in place and discusses reasonable accommodation. It discusses how you get proof of vaccination. And it requires that all federal contractors designate a person to oversee compliance with these rules. That there's also a September 30th guidance, which I'll talk about in the next slide. But one thing to be aware of is that this requirement applies when the simplified acquisition threshold for a federal contract is $250,000 or more. The other thing that has happened is that federal contractors and subcontractors are required to have in their contracts a clause stating that the contractor or subcontractor will, for the duration of the contract, comply with all guidance put out by the Safer Federal Workforce Task Force. And what that means is there needs to be a clause in the contract that refers back to whatever guidance the task force puts in place. So if the task force guidance changes, that means that the requirements under that contract will change as well. And basically that means that those individuals are going to have to be vaccinated according to whatever the task force is saying. Next slide, please. So as I mentioned, there was also a guidance put out on September 30th, and that September 30th guidance actually attached a template of the provision that has to be in contracts. And it helps that language is going to, again, refer back to whatever the Safer Federal Workforce Task Force says should be the guidance, that whatever the requirements are. For example, right now, everybody has to have 2 shots and then wait 2 weeks if they have Moderna or Pfizer. What the task force may do at some point is add booster shots as a requirement if the CDC says that's required. So these contractual provisions will mean that on the ground, things are going to need to change. I don't want to spend a lot of time on this slide, but suffice to say, there are some contractors who will have to include a clause in their contract that basically says they'll adhere to the vaccine mandates. And there are some contractors who, because of the timing of their contracts and whether they're extended or not, are encouraged to have this vaccine mandate included in their operating procedures. But eventually, if the contract is extended, those individuals, those contractors would have to include the clause as well. So there is some that are mandated to have this vaccine mandate compliance, and some that are just encouraged. Next slide. And as with federal employees, if there is a federal contractor who needs to hire a worker on an urgent mission critical assignment, and that worker is not vaccinated, there is the ability to hire that person and to let them go through the vaccine process. And as long as they're vaccinated within 60 days, they can continue to work on that project and on that site with all the safety protocols. Okay, I just want to make sure that all right. So the guidances that we've seen, again, there's September 24th, there's September 30th. And if you go to the Safer Federal Workforce Task Force website, there is a list of what's new. And if you look at those guidances, they provide some very helpful overview and information for what federal contractor employers are supposed to be doing. For example, there is a posting requirement. Any employer that is a federal contractor is going to have signage as people enter the building telling them what the safety protocols are. Additionally, it's going to be, these guidances make clear that it's very broad coverage. It's intended, the spirit of this is to make sure that as many unvaccinated people as possible get vaccinated. So it covers employees, it covers remote workers. And it's going to cover, as I mentioned earlier, even those employees who are not actually working on the federal contract, as long as they are kind of overlapping or sharing space with people who are working in the federal contract. If an employer can affirmatively show that a worker does not have any contact with anybody working on a federal contract, that employee is not working on a federal contract, they don't share a restroom or a kitchen facility with somebody working on a federal contract, then the employer can kind of segregate that part of the population and will not be required to make sure that those employees are vaccinated. But that's probably going to be a pretty high burden just because of the nature of workplaces. Proof of vaccination is also discussed in these guidances, and employers who previously asked for proof of vaccine now have to ask again and actually make sure that the employees swear under the pains and penalties of perjury that they are giving truthful information. There's also record retention and confidentiality discussed in these materials. So I would recommend that the people look at those. And I will just say, for those employers who are looking for forms, they're on the October 4th guidance. The federal government has actually provided 2 forms that may be helpful to employers that they can use to ask their workforce, do you need a medical accommodation or do you need a religious accommodation? And it provides some questions. So just a tip for a template that may be helpful. So I am going to turn this over to Jim now for healthcare and large employers.
Great, thanks, Karen. And so, I mean, while we have a lot of information, and I think, and a lot of that is very useful for employers, especially federal contractors, to digest, there are still questions that remain. and the devil's in the details about segregating employees from one part to another, whether they're working on a contract and so on, and whether it's an ongoing contract, and whether or not the provisions of products and services meet the standard for a subcontractor test and so on. But we'll see. I mean, I think these things are just, again, are evolving. So let's talk about healthcare facilities. Before the path of the pandemic, a lot of healthcare providers, in particular, we're talking about hospitals, clinics, nursing homes, assisted living facilities, and so on, home healthcare agencies even, were mandating the vaccine. And were they allowed to do that? Well, if you go back to when the vaccines first came out in late December of last year and early January with the FDA emergency use authorization, first for Pfizer and then for Moderna, and then much later for J&J, the EEOC came out with guidance, and the guidance initially said, in addition, can you ask if you're vaccinated, and can you ask for proof? And the answer to both was yes. They also said, can an employer mandate the vaccine? And EEOC's response was, well, yes, if it's job related and consistent with business necessity. And as Karen said, as long as you also include there the possibility for a medical or religious exemption. So what is job related and consistent with business necessity? Well, all along, we thought it was largely healthcare facilities and first responders and so on. But the EEOC provided no guidance in that regard. In fact, it could be any type of workplace where it is, again, job related and consistent with business necessity. So you would have assumed that healthcare providers were fully vaccinated before path of the pandemic. Yet that is, as we're finding out now, that is not the case. So this part of the path of the pandemic deals with healthcare facilities. And again, we're talking about hospitals, nursing homes, clinics, healthcare, home healthcare providers, and so on. And best estimates, it's about 17 million healthcare workers that are covered by this. And it provides they must be, as Karen said, fully vaccinated. And so that includes, just like we're talking about with the federal contractors, related, but not direct staff. It includes clinical staff, but it also includes staff not directly involved in patient care. So largely, and why is that? Just like with the federal contractors, because you may have someone in accounts payable or a receptionist or someone in human resources or otherwise, or maintenance, making their way into clinical areas. So it's all encompassing. And what is the possibility of non-compliance, or what the consequences of non-compliance would be? Medicare and Medicare funding could be in jeopardy for non-compliance. And that is obviously a very serious issue. Going back to the federal contractors, you could have debarment from, you're no longer eligible for a federal contract. So similarly, there is the sword of Damocles of losing Medicare or Medicare funding for non-compliance with this. And you would think that healthcare providers, those that have had direct contact with a patient in a healthcare setting, someone with a compromised immune system or otherwise, that they would be immunized. But we're finding out, of course, that that's not the case. So, and what is the other issue? And something we talked about off camera before we started today was the staff shortages with healthcare facilities. But we've seen already in New Hampshire, whether we're talking about Dartmouth Hitchcock or other large providers with the mandate, there's pushback and from clinical staff and others, but also the potential for exacerbating the staff shortage. So we're waiting for more guidance to come out from the CMS with regard to additional information with regard to this part of path of the pandemic, but and those rules get into some of the issues that we already talked about, with paid leave, testing time, and things we'll talk about with large employers as well. That again, the small but important details in implementing this vaccine mandate. So if I move on now to the large employers, and this has been one where, New Hampshire has a significant number of large employers, meaning employers as defined by the path of the pandemic with more than 100 employees. they must be fully vaccinated, but there's no deadline. As there is a deadline, as Karen mentioned, for federal employees and also for federal contractors, November 22nd, December 8th. There's no deadline yet for large employers to have their employees be fully vaccinated. We also don't know yet how OSHA, who's charged with coming out with these emergency technical standards, will determine how employers count their 100 employees. Is it combining facilities, affiliates, subsidiaries? Is it within like with the FMLA, within a certain geographic distance? Is it going to be full-time or part-time? Could it be seasonal? Is there a period of time in which you capture that number? Meaning in a lot of employment laws, there's a look-back period in the current and preceding year. For X number of weeks in the current and preceding year, how many employees did you have? We don't know yet how that 100 employees will be counted. There will be, however, unlike with the federal employees and with contractors, there is opt-out possibilities with weekly testing. And we'll talk about that. While that is not clear yet, because we don't have the ETS guidance from OSHA, we assume that the opt-out testing is only for those with medical or religious exemptions, but we don't know yet. And in some ways, if you think about it, if it was opt-out testing for someone simply that refuses to get the vaccine and it's not covered by a religious or medical exemption, then what's the purpose of the mandate? Because then you're not going to get the objective, which is to have as many people vaccinated as possible. So proof of the vaccine or vaccination. Now we saw with the federal guidance that you could have a digital record in addition to the CDC card that you would get when you get vaccinated, or proof from a public health facility and so on. That could tip a bit of the hand of OSHA as to what they will accept. And in actuality, how many of you carry around your actual CDC vaccination card? Most of us have taken a picture of it at least and put it on our phone, but we don't carry the card around with us. Like you don't carry around your social security card, your birth certificate, and so on. So whether a digital record will be acceptable. And we'll talk about that in a minute too, with regard to record retention. So are you taking a picture of, a photocopy of someone's CDC card? Are you taking a copy of their public health record? How would you do a snapshot of a digital record, and how are you going to retain that? And the same is true with regard to testing. If there is opt-out testing weekly, we don't know yet what the type of testing is going to be. We assume, based upon what we've heard from the federal government, that they've spent a lot of money on buying home test kits for rapid testing, that's the way to go. In fact, for purposes of logistics, that makes perfect sense as well, because PCR testing takes anywhere from 3 to 5 days for the results, which makes no sense if you're doing weekly testing. So, but this is effectively what the large employers are. 100 or more employees, you've got the exemptions possible, you've got opt-out testing, you've got proof of vaccination, and then it's record retention issues. And with that, as Karen said, confidentiality will go along with retaining those records. But again, we're waiting daily for ETS guidance. Now that guidance, OSHA, again, it was September 9th that the president directed OSHA to do that. And on October 12th, OSHA submitted their proposed ETS guidance rules to the White House. And the White House promised expedited review of those, but now we're October 27th and we still haven't seen them yet. Next slide, please. So when those standards come out, we hope they're going to answer how to count the number of employees for large employers, how to track vaccination and testing for purposes of, again, if you have someone works Monday through Friday, do they do the home test kit on Sunday and somehow transmit those records of a negative test to the employer so they can get into the workplace, have access to the workplace in the next day? Who pays for the testing? Well, in New Hampshire, we know if you have a medical test directed by the employer as a condition of employment, the employer is supposed to pay for the test. But what about the time for testing? Well, the path out of the pandemic says that the employee will not lose income, wages, or for the lost time for receiving the vaccine, or if they're suffering any side effects of receiving the vaccine. Well, does that mean that the employee uses his or her paid time off, PTO, sick leave, earned time, or whatever. And what if the person doesn't have that time? We don't have the information in that regard yet. And remember, under the FFCRA back in last March, when employees took emergency sick leave or emergency family leave, they got a payroll tax credit through the federal government, quarterly payroll tax credit. There is no such provision in path out of the pandemic at this point, but that makes perfect sense. Are you asking employers to advance time effectively? And then, of course, the practical question for HR professionals is, well, how do I determine if someone is actually suffering side effects as opposed to just simply wanting to take advantage of this opportunity, having gotten the vaccine, to take a few more days off and not have it charged their paid time? We don't know that yet. All we know is from the earlier guidance from the other statutes I mentioned earlier that employees were not required to use their paid time off first. Instead, they would get the opportunity for emergency sick leave or emergency family leave. So what about remote employees? As Karen said, for purposes of federal contractors, they may be required to get the vaccine, but what about for large employers? If they're fully remote, do they need to get vaccinated and testing? Don't know yet. And there are more questions as well. So let's talk about the legal challenges, because there are many, and some were announced just as the president effectively finished speaking on September 9th. And whether you watch cable news or what your local paper or whatever your news source is, you've been flooded with this about the potential challenges, constitutional challenges like we're seeing equal protection claim in Arizona, or states like Florida and Texas with their challenges. Here, even in New Hampshire, there's a bill in our legislature that says that local and state officials are prohibited from enforcing the federal mandate for vaccines. You also have a state statute here that talks about, even apart from path on the pandemic, that says that vaccination status cannot be a bar to someone gaining access to the goods and services available at a place of public accommodation. And again, that's subject to questions and interpretation. So the questions are, how do you comply in states that ban mandates? A very good question. We basically have a brewing war between the federal and state governments, or at least the state governments that resist the vaccine mandate. And further, you have, and that goes from state governments down to county governments, which are a creature of state governments, and so on, and down to the municipal level. And the question is whether or not the federal government can dictate effectively compliance by the states and the local governments. There are other challenges as well that the statute, whether the executive order and the like, are overly broad, that OSHA doesn't have this authority. And if you even look at the last several ETS guidance that have come out from OSHA in recent years, 2 of them were stayed and 4 were completely vacated. So is that going to happen here? Well, if you read the tea leaves and you see what's happened in the last year with regard to vaccine mandates, most, if not all, of the court decisions where vaccine mandates have been challenged have been upheld in favor of the mandate. So that's entirely possible here too, but you have a different element here too with regard to constitutional and other objections to the mandate. A question, of course, is an ETS appropriate standard? Because the ETS standard, and that's, by the way, when that goes through rule, it's expedited rulemaking, and it's only good for effectively 6 months. Thereafter, if it's to be continued, you have to go through a more involved rulemaking process on the federal level. And the standard is, there is a grave danger in the workplace. And so, as opposed to addressing a public health crisis. So the question is that too much authority given to OSHA to address this issue? And there are arguments on both sides of the aisle on that. And then, are we imposing more paid leave on employers? Meaning that if they're not going to be reimbursed, if there's not going to be a tax credit, is this going to be more of a burden on employers? And Tim deals with this all the time with the employers in the chamber. The great burdens on, even though there's been federal assistance through most recently the American Rescue Plan, and before that, the CARES Act and so on with PPP, it is fair to say, I think, that there's been great stress upon employers, businesses of all types and sizes. And the question is this just one more on top of that? And let's add another of that. And the obvious is the elephant in the room. What about the employee that doesn't, simply for philosophical, personal, or political reasons, doesn't want to get the vaccine? And you run the risk of losing that employee. Or just in general, we're dealing with what's called the Great Resignation. That one, because employees work remotely for a period of time and don't want to come back to the office, and others that don't want to get the vaccine, or others because we have a wage war going on effectively out there, people migrating from one thing to another, or just re-examining how they want to live their lives. Just additional pressure on employers. But this is one more thing. If the path of the pandemic requires advancing the time to get the vaccine and to recover from it, whether that's additional time. Now, it's probably not a lot of time in that regard, but it's just one more thing for employers to deal with. Next slide, please. So in EEOC's guidance, which I referenced earlier, and again, the spring EEOC came out with additional guidance on this, with regard to vaccinations, that an employee could indeed refuse to get the vaccine for medical or religious reasons. And if so, reasonable accommodation should be considered. And EEOC just again came out with additional guidance just just a week ago, effectively saying the same thing: consider reasonable accommodation. So what is that? For the medical standard, it is basically it's reasonable until it's not. It's until it represents an undue burden or undue hardship. We'll talk about that in a minute. But let's go to the first part of that. If someone requests, and as Karen mentioned, the forms are available, and we've been assisting clients with that for some time. If they're requesting a medical or religious exemption, how do they do that? Well, it's pretty straightforward. There's no magic language or special clauses, but it's basically, I can't get the vaccine because. And so for medical, it's supported by some sort of medical reasons, and that's supported by documentation from a medical or a healthcare provider that the person has a health condition, or perhaps the medications that they're taking, the alchemy of that with the vaccine. There are concerns about that. In the early days of the pandemic and the vaccine, there were questions as to whether or not women that were pregnant should get the vaccine. Then CDC came out with guidance about a month and a half ago saying that pregnant women should get the vaccine. So there's been a lot of changing information here, but for medical, it seems pretty straightforward. And then, so if there's a medical reason supported by a healthcare provider, then the employer then has to say, can the person perform all essential functions of the job with this reasonable accommodation? And that's a back and forth. And the reasonable accommodation analysis typically is, what's the cost and effect upon the organization? And just because the employee says that what he or she wants and what his or her healthcare provider recommends doesn't mean the employer has to adopt it. It's just that there's a back and forth and exchange of information. But employers are encouraged to be flexible in that regard. So what about religious? A sincerely held religious belief. What is that? Well, in the early days of that, the vaccine and the guidance that came out from EEOC was, well, you look at the doctrine and the teachings of someone's professed faith or religion, and you would look at that. But then EEOC came out with guidance that, well, but then again, a person can still have a sincerely held religious belief, but depart from the teachings of that church, leaving employers to say, okay, but what does that mean? And so some employers whole cloth adopted, if someone says, this is my sincerely held religious belief, they approved it. Others considered it to be a dodge and said, we're not going to approve it. We don't believe you. And that typically came up where someone, and this is a generalized statement, but if someone listed political, philosophical, medical, and religious reasons, well, then how sincerely held is this religious belief? Then when you've got these other things thrown into the kettle as well. But when you've got that information, then what do? And then you look at, and it's a lesser standard, and the question is whether or not the person can still perform his or her job, the essential functions of it, with this accommodation. And that's where employers have been and will continue to be, whether this path of the pandemic remains in place and it is not subject to, and legal challenges don't cause it to go away. And if you still have an employer that has a vaccine mandate. So I mentioned earlier, can employers ask an employee if they're vaccinated? EEOC guidance early on this process said, yes, you can. That is not an improper disability or medical inquiry. And can you ask for proof? And the answer is yes, you can ask for proof. However, you have to be careful not to elicit more information than necessary about the employee's current impairments or health status that are not relevant to that accommodation discussion. And similarly, you don't ask information about family history and so on. Next slide. Other issues that come up with regard to other legal issues that come up with regard to the mandate. Employees who refuse to be vaccinated may be relieved from duty. They may be transferred or required to work remotely, but employers cannot retaliate against an employer for refusing the vaccine. Well, of course, that raises an issue. So someone says, well, wait a minute, I've refused to get the vaccine, and therefore you've relieved me of duty. You've put me on unpaid leave, which a lot of employers are looking at right now. You've transferred me, or you required me to work remotely. Isn't that a form of retaliation? It depends, but I think if the person, again, the vaccine is job related and consistent with business necessity, you can say, well, you really can't perform the job unless you do these things, being segregated, working remotely, transferred to a different type of job, and so on. In a union environment, now in New Hampshire, there are not many private sector unions. There are some, but not many. But we have a lot of public sector unions. In a union environment, the question is, can you mandate vaccination, or is that the subject? I mean, you would do that under the management rights clause, or would you do that as a, would you have to bargain over that with the union? Recent decisions that have come down in that regard suggest that employers can indeed mandate the vaccine through management rights and not have to go through collective bargaining, but you may have impact bargaining that comes up as a result of the mandate. Vaccination records and inquiries related to accommodation should be treated as confidential records. What does that mean? Well, you're all familiar with the Americans with Disabilities Act and what that means, and that medical records are to be kept confidential, meaning segregated from other personnel files, and are only disclosed on a need-to-know basis, first aid and otherwise. But a question has come up then, and this has come up a couple of times, and Karen, I know you've seen this too, is, but can I tell a supervisor whether or not someone in their group is vaccinated or not? Or can I share that with coworkers who are afraid of coming back to work unless they know who's been vaccinated? Well, can you share with a supervisor, perhaps for purposes of understanding the accommodation process and PPE and changes in someone's schedule or transfer to segregation and so on? How about with sharing with coworkers? I would say no. They don't have a right to know that information. And so can you terminate the unvaccinated employee? The general answer is yes. If the person is not subject to exemption, or if they are subject to exemption and there can be no reasonable accommodation. But that can be hard because once on leave or terminated, you may never get that employee back once we pass this healthcare crisis. Next slide. So again, EEOC says vaccinations are not medical exams under the ADA, but still they must be job related, consistent with business necessity, or justified by a direct threat, and no broader or no more intrusive than necessary. I think path of the pandemic has basically taken that decision-making calculus away from employers for covered employers, and basically said that if you're covered by the mandate, then you have to have your employees vaccinated unless they fit within the exemptions. Turning that back to Karen now.
So I don't see a lot of questions. I do see we're getting close to the top of the hour. So I'm just going to go pretty quickly through these slides on reasonable accommodation to talk about the process. Jim has given the overview from a legal perspective, but basically from medical and religious reasons. Next slide. Talking first about the religious exemptions, right? So what are employers supposed to be doing during this period of time? As I mentioned, there are some templates out there. We've been helping companies put together questionnaires to their employees. Basically, the employer should be distinguishing between whether there's a sincerely held religious belief or some other form of belief, a political, philosophical, some other thing that doesn't rise to the level of a religion. The problem here is that, number one, employers aren't used to doing this. And number two, the definition of religion is actually very broad according to the EEOC. There are several guidances, and as of October 25th, the EEOC updated its guidance, which is called What You Should Know About COVID-19 and the ADA, Rehab Act, and Other EEO Laws. So I commend that to you. But basically, it is not just saying, do they cite their particular religion and give quotes from the Bible or quotes from some other religious resource. You have to look and see what is the nature of their belief. Does it rise to this level of ethical, moral, what is right or wrong, which is how the EEOC is defining religion, and understanding that just because somebody's belief doesn't align with the official doctrine of their stated religion doesn't mean that you can just discard it. You do need to look and see, have they articulated something that sounds like a sincerely held moral, ethical, fundamental right and wrong type of a belief, or is it something else? So when you have that information and you understand from the employee that their religious belief conflicts with a job requirement, and in this case, the vaccine mandate, then, the question becomes, what do you do with that? And, in terms of what types of information employers can ask for, as I mentioned, there are some templates out there, some questionnaires. Employers will differ depending on the type of work environment and what the employee's job is, and are they remote or not, in how hard they press. Does the employer have any legitimate reason to question that person is saying a religious belief or that it is sincerely held? The EEOC's default is to say that employers generally should not be questioning the sincerity of somebody's religious beliefs, which puts employers in kind of a tough spot. Next slide, please. But always keeping in mind that if somebody requests an accommodation, it would be an undue hardship for the employer to grant that accommodation, the employer does not need to. And the undue hardship, that is also a moving target. It depends on the employer. And even though we know it is slightly easier to show undue hardship for a religious accommodation than a medical accommodation, there's really no hard and fast rule as to what that means. So look carefully at what accommodations you can provide. What alternative accommodations? Could somebody work from home? Could somebody work in an isolated part of the building? What could the accommodations be? So I don't know if there's difficulty advancing the slides. Okay, perfect. That's exactly where it should be. So secondly, what happens if somebody requests the medical accommodation? Same sort of thing. There are forms. I think employers are much more confident and comfortable and used to asking for medical documentation relating to a disability. So that shouldn't be treated any differently. Remember, you have to engage in that interactive process with the employee to figure out what are their limitations, why can't they get the vaccine, what would the result be if they did, and what accommodations might they be looking for. And then once you have that idea of what what the accommodations are, then we need to look and see whether they were an undue hardship. And keep in mind that if somebody is saying that they cannot be vaccinated and they want to continue to work in the workplace, the employer does have the right and obligation to figure out if there's going to be a direct threat in the workplace because of that unvaccinated person. Next slide. So the direct threat analysis has 4 parts to it, basically looking at the risk, the nature of the risk, the likelihood of the risk, and the imminence of the risk. So you'll need to evaluate in your own workplace if somebody who is unvaccinated but follows all the regular safety protocols, will there be a risk to the other people that is sort of a direct threat that is something that you cannot bear. Next slide, please. So if there is an unvaccinated worker that poses the direct threat, the EEOC doesn't say you can automatically terminate that person if there is a way to accommodate. So again, you're balancing what are the reasons that they're giving you for not being able to vaccinate. Is there an accommodation you can give them? Will that accommodation present an undue hardship? If you give them that accommodation and it means they go into the workplace, is there going to be a direct threat? So all of this is tied up and is tying up employers at this point in time.
We do have a couple of questions, but before we get to those, I want to just get through a couple of quick things here. What are the other issues to consider? Basically, while CDC has sort of slid back in the things that we focus on, certainly focusing on the OSHA guidelines as they come out, and that will be hopefully the ETS any day now. And as Karen talked about, direct threat. And then next slide. Union issues, and this is one of the questions that's come up, we'll address very quickly. Is there an obligation to negotiate? Well, I referenced there was one court decision that came out recently that suggested no, you could do it under management rights, but that was one court. And so, but even if it is under management rights, there is a thing called impact bargaining. What does that mean to the employees? And you have to bargain the impact, and the answer likely is yes. Next slide, thanks. And then Hipaa, that comes up all the time. People misunderstand Hipaa. And if you're not, most employers are not covered by Hipaa in that they don't provide a healthcare service to an individual. So Hipaa is generally not applied, but there is a Hipaa privacy rule that may apply. So basically keeping the information on vaccination and testing as a confidential medical record will likely, and also not disclosing that information without need, it will likely keep you protected. And GINA, the Genetic Information Notification Act doesn't really apply here because you're not going to really delve into the genetic history of family members and so on. These questions come from HR professionals, so it shows that they are informed and they are concerned, but we can provide some relief in that regard, since these are not directly implicated by the vaccine mandate. Next slide, please. So other workplace considerations, the short answer is, can employers provide incentives to get the vaccine? That was really before path out of the pandemic, but it's still going on right now. Can you provide an incentive? The answer is yes. This goes back to the EEOC wellness guidance that says you can provide that. And there's some additional guidance that came out recently with regard to the ACA that said that basically there's a standard with regard to premium relief, whether it's for an incentive or for a surcharge, and whether or not that can be done with regard to the vaccine. The short answer is yes, but it actually gets more involved than that. Before we get to best practices then, which is how we'll wrap up, we've got a couple of questions to answer here. And I'm going to just pop those up on the slide. Again, one was when the employees could, the question was whether or not you can mandate the vaccine without bargaining for it in the private sector union. Again, it depends. Our position is it should be a management rights activity, but there should be impact bargaining. Weekly testing for exempt employees is going to put a great strain on an already strained healthcare system. It can take up to 4 hours to get a COVID test. Will the employer need to pay for that 4 hours? And what do you do for proof? We're waiting for the ETS in that regard, but the path out of the pandemic says that basically the time employees should not lose income or wages based upon the time to get the vaccine, to recover from side effects. And then it was, we know for purposes of under New Hampshire law, a required medical test is covered by the employer. And the question is whether it's considered hours worked. It may be. Certainly, if you could have the test done during working hours, that makes it easier. Our hope is that when the ETS comes out, it basically suggests that on off days, when someone is not working, they take a home test, and they can submit that proof to the employer. But again, we're waiting for guidance in that regard. Karen, do you want to add anything to that one?
I will just say that in June 25th, I think OSHA put out an ETS for the healthcare workers, healthcare environments. And in that, the FAQ, they actually say that offering 8 hours of paid leave per shot, so a total of 16 if the employee gets 2, would be considered reasonable. But they also did say that that time could be taken from available paid leave that the employee might have accrued. Doesn't really answer what happens if they don't. So I hate to say it, but 4 hours might not actually be even enough, because the way that the healthcare ETS says it, you're also paying for travel time, not just taking the test and recovering from it, but also travel time. And so they're saying 16 hours for the course of the vaccines.
And then now if we can just, as we conclude our program, sort of suggestions for best practices. And as we do, Tim, one of the questions that came up was, will copies of today's slides be available? And we'll certainly let you folks send those out to the attendees.
So I'm just going to quickly go through the best practices. You know, we're obviously there's a lot changing. I just during this presentation went on to see if ETS were issued. Don't see them yet, so keep on alert for those. It's going to be important to have policies that talk about vaccination and testing. And just make sure that you are communicating with your workforce about what is expected, what's required. And for that, I would also say, Jim mentioned, you know, we know that for some employees, there are deadlines for federal contractors, but for others, there are not. And we have found it is just very practical for an employer to say, here is the date by which you must submit a request for an exemption. Part of that is so that the employer is really addressing everything all at the same time and being consistent in its decisions, but also so you don't have one person get an approved exemption and then hand it out to the entire workforce and everybody then uses that same format. So it is important to communicate those dates, set that date. Above all, the confidentiality of medical records, and I would even say the religious exemption records. You know, employers are getting way more information about people's personal beliefs and medical situations than they ever have before, and that can turn into some form of a discrimination claim down the road. I told you in October 2021 that this was my religious belief, and when I was fired in February of 2022, it's because you don't like people who believe that. So be very careful about maintaining and respecting the confidentiality of those records. The EEOC's message and OSHA is these are all very broad. This is a time for employers to be as flexible as possible, especially given the challenges in replacing workers. So be flexible, but stick to what you can ask for so that you don't, you know, that you can show that you are being consistent and fair. But if you find that someone is violating your policy, you're also going to want to take quick steps to do that, again, with the ultimate goal of keeping your workplace safe. So with that, I don't know if any other questions have popped up, and I think we have hit our time. So Tim, we'll turn it back to you unless, Jim, you have any other final thoughts.
No, just thanks for joining us today. We really appreciate it. And we appreciate that all the work that you folks are doing out there dealing with trying to keep your workplaces safe and also retaining your employees. There's a lot to digest. There's no question. We're here to help. We will be issuing a client alert and an alert through LaborNet as soon as the ETS comes out. But in the meantime, we're always happy to help. And here's our contact information.
I just want to thank both Jim and Karen. There's a ton of information, really good stuff. Devil's in the details. It seems like we've got a lot of guidance coming out here, but a lot of unanswered questions as well in terms of legal challenges and how states and federal government are going to interact and how this is going to be enforced. And so I'm just going to set the table. I know that down the road, we'll be doing some follow-up webinars on this topic to keep you well informed. And just hats off again to Jim and to Karen for doing such an outstanding job with this presentation. I hope we can invite you back at a future time to fill in some of the blanks that no doubt are going to occur.
Thanks so much.
Happy to join you all. Thank you.
And thank you all for being here. We appreciate it. And we will please stay tuned with the chamber and we'll keep you informed on other important issues as they arrive. Have a great day, everybody.
Thanks. Bye-bye.